Let's now speak about the relationship between the three arms of government, the legislature, the executive, and the judiciary. Joining us on the line is the president of the Law Society of Kenya, Nelson Harvey. And of course, we want to talk about what we've been seeing as a standoff, the standoff between the judiciary, the Judicial Service Commission, and the president, and the appointment of 41 judges that whose names were taken to the president and told, we have gone through an entire process, recruitment process. We have interviewed these individuals, and we believe that these 41 are suitable to be appointed as judges. The president, to date, has not appointed them. There has been back and forth. The issue has gone to court. Judges have delivered their rulings on this. There has been, a lot of conversation. The Attorney General has said one thing, the Chief Justice has said the other, and we still don't have these 41 judges taking up office. Now, the question that we want to ask this morning is whether this is also creating an injustice. But let's welcome our guest for this hour, the President of the Law Society of Kenya, Nelson Havi. Good morning, sir.
Good morning, Eric Latif.
Welcome to the Situation Room. You're in the room with Nduoko and C.T. Muga. Now, Nelson, let's just get straight into it and look at this standoff over the appointment of the 41 judges. What do you make of it? I know the Law Society of Kenya has made various statements around this, but I just want to hear from you this morning. Is this an injustice? Does the president have any grounds to halt these appointments?
Latif, what the President of the Republic of Kenya has done in the recent 1 year, insofar as the swearing in of the 41 judges is concerned, is a gross violation of the Constitution. I say it is a gross violation of the Constitution because the question as to the scope and power of the President, insofar as the issue of appointment of judges is concerned, is one that has been settled by courts of law in Kenya. It therefore baffles why a president who sought to uphold the Constitution will find it convenient to refuse to swear in judges. Mm-hmm. And when he's asked to explain the reason as to why he doesn't want to swear in these judges, he claims that he has confidential intelligence reports which indicate that some of the judges do not meet the integrity requirements for swearing in. Mm. And look, we have witnessed the bickering between the executive and the judiciary. The Chief Justice insisting that these 41 judges must be sworn in because the wheels of justice cannot move smoothly when we don't have the judges who are required to preside over the hearing of the cases. And more importantly, it interferes with the independence of the judiciary. And if the judiciary cannot function in the manner in which it's supposed to function in a constitutional democracy, of which Kenya is, then we are likely to degenerate into a state of anarchy. Therein lies the problem, Latif.
If I may ask, Mr. Harvey, is there anything within our constitution that would enable our legal system to take action against the president if we take the view that indeed he is abrogating the Constitution?
Yes, the Constitution has provided for this. The president may be impeached for several grounds, one of which is a gross violation of the Constitution. Now, taking into account that the judiciary is one of the arms of government, which plays a pivotal role in the determination of disputes amongst citizens and between citizens and the state, it becomes evident that when the President of the Republic of Kenya refuses to swear in judges, and a court of law, and in this particular case, this matter went before the High Court, and the High Court determined as a matter of fact and law that the President had violated the Constitution in his failure to swear in the judges. Now, whose responsibility is it to oversight the president and remedy this transgression? Mm-hmm. This responsibility is given to Parliament. Parliament has the power to initiate proceedings for the impeachment of the president. But does Parliament have the goodwill? Does it have the wherewithal? It has the wherewithal. I doubt whether it has the goodwill. I say so because it has been my position, which is strongly held by a majority of Kenyans, that Parliament has been emasculated by the executive. And this is because if you look at the manner in which the National Assembly and the Senate act, it is as if they're acting on express directions from the executive, by extension from the president himself. And lately, bearing in mind that there was a handshake, it looks like there is a pact between the President of the Republic of Kenya and the person who will otherwise have been the leader of the opposition.
If we're looking at the reasons as to why the appointment of these judges has not taken place, in your opinion, is there any merit in what the president has given as a reason as to why they have not been appointed? Or do you see it as a smokescreen for something else?
There is no merit whatsoever because the Constitution itself has contemplated a situation as the one which the president claims is a predicament that precludes him from swearing in these judges. What is the president supposed to do? The president, through the state agencies that are claimed to have collected information against these judges, is supposed to originate a petition before the Judicial Service Commission against any of the judges who have been recommended for appointment. And it must be understood from the information that has been filed in court that the grievance that the president claims to have is against serving judges of the High Court who have now been appointed as Court of Appeal judges. The grievance does not relate to any of the 27 nominees who were sourced from private practice. So that if a judge is unsuitable for appointment as a Court of Appeal judge, yet is sitting in the High Court, why is he sitting in the High Court in the first place? But this is what ought to have been done ideally. The president ought to have sworn in all the 41 judges and immediately thereafter ensured that the removal process, which commences with a petition before the Judicial Service Commission, is commenced with those he believes fall below the integrity threshold for a judge.
Mr. Harvey, I'm asking this as a layman, of course, according to our constitution and our laws, can the President of the Republic of Kenya be jailed?
No, the President of the Republic of Kenya cannot be jailed because for one to be jailed, he or she must face trial, must be convicted, it must be sentenced. The President of the Republic of Kenya is immune from criminal and civil prosecution for the term of his office. But that does not mean that there is no reprieve in the event that the president commits an offense or misconducts himself. No wonder, therefore, the people of Kenya found it prudent to include a clause in the Constitution which gives Parliament the power to try the president. Because when Parliament is conducting a trial of a state officer, it is not limited by the strictures and the procedures that will ordinarily encumber a usual or a customary criminal or civil litigation in court. Because Parliament acts like a court of public opinion. So that the correct forum to try a sitting president is Parliament.
So if indeed you say during the term or the tenure of the president, they have immunity, what happens after? Can these cases follow the individual after they've left office?
Of course, these cases can follow individuals after they have left office. And the history of the world is replete with many of these examples. You remember General Pinochet. You remember General Omar al-Bashir, who is now facing trial for a coup he conducted in the 80s. Just to mention but a few. It must, however, be understood that those countries do not have a transformative constitution as we do, and that will explain the handicaps that they had when those leaders were in office. And for instance, General al-Bashir, who is our neighbor here in Sudan, was invited to attend the promulgation of the constitution on the 27th of August 2010. And you saw the manner in which he was treated as compared to other international dignitaries who will otherwise be considered more respected than him. But in conclusion on this particular issue, the quality of leadership of a country is representative of the people. As one former American ambassador in Kenya said, choices have consequences. How do we end up with a situation of this kind? Is this something that we can remedy in future? Why do we have a chapter in the Constitution that deals with leadership and integrity? Why do we have an article in the Constitution that has principles of good governance? Are we really enjoying good governance? Is there leadership and integrity amongst our leaders, and in particular, those at the helm of leadership of this country? These are questions that all Kenyans must interrogate seriously, so that as and when we go for an election, we do not end up electing individuals who find the Constitution as an inconvenience. Because if that be the case, then the loser will always be the common mwananchi, as it is right now.
You've raised the issue of leadership and integrity and the principles of good governance. I want us to go back to that after some point, but just sticking on the issue of the appointment of these specific judges, we have heard from the former Chief Justice, Dr. Willie Mutunga, and talking about the experience that they had in 2005 of a similar matter, standoff of our appointment of judges, and they had a meeting between himself, the President, and the Speaker of the National Assembly, and this matter was sort of resolved. But he says that from where he observed it, his observation was this was ahead of the executive feeling left out in the crucial appointment of judges. And, well, despite the fact that the Attorney General sits in the JSC and there are two other direct nominees of the President who sit in the JSC, but the President feeling that there's some information that he's privy to, that he should be able to use to weigh in on the appointment of judges. What do you say to this? Is this not maybe part of the implementation process of the Constitution, where the two heads of the two institutions are saying, what role do I have to play in this? Am I just a rubber stamp?
Look, the problem we're having with is not one occasioned by a lacuna or a failure of the law to provide for a conducive environment to accommodate the head of state and head of government, insofar as this concern is an issue. Because as you have clearly set out, the President and the executive at large is represented in the Judicial Service Commission, first by the Attorney General, and two, by three appointees of the executive. So that those appointees will have been seized of that information that is claimed to be in the peculiar knowledge of the President. They ought to have interrogated this issue. But more importantly, let's go back to what happened much earlier when a similar problem prevailed. We've been told that the Chief Justice then, the Attorney General, as well as the Speaker of the National Assembly, prevailed upon the President to ensure that the judges were sworn in. And that is a manifestation of the big man syndrome, where a leader wants to be appeased every time an action is undertaken by an arm of government, so that it is said he has a role to play. But anyway, this is Africa, and we are accustomed to appeasing the big man. What have we done? The Chief Justice himself has stated publicly that he has sought an appointment with the President so that they may discuss this issue. On my part, I have sought an appointment with the legal advisor of President Uhuru Kenyatta the Attorney General, retired Judge Paul Kariuki, and the Solicitor General Kennedy Ogeto, has even made efforts to contact the president through his other political advisors. And they've been adamant they do not want to say it. And if you look at it from that perspective, how can you stretch your hand to shake the other hand that has been folded into a fist? So that the stagnation we have right now is one that has been occasioned by the failure on the part of the president, his advisors, to give momentum to a discussion that will have yielded positive results within the shortest period of time.
So, Nelson, what's really at play here? Because clearly, the Attorney General, who is a senior member of the legal fraternity, former president of the Court of Appeal, knows very well what the law says. The Solicitor General understands what the law says. The president has lived this experience before. And yet, we are not getting this appointment of the 41 judges. What do you think is really at play?
Sorry to say, the way I could categorize this situation is this. We have criminals in public office. They are competing with the public in subverting the rule of law. They are competing with the public in violating the Constitution. There is no other way of explaining it. And then therein lies the problem. Should laws be there for the observance of the people and for the disobedience of the leaders? That is not how governance is supposed to be undertaken. That is not how the social contract is supposed to be performed. And it will be a matter that may surprise you, but the reality is this. The government of the Republic of Kenya does not obey any court orders made by the judiciary. Most of the decisions made by the government of Kenya are challenged in courts of law successfully, and I will put it at about 80% on the success rate, meaning that 80% of what is done by this government is against the Constitution. And these are the people we have entrusted with the responsibility of formulating policy, of implementing the laws that are passed by Parliament. That is, there is a big problem.
Nelson Harvey is the president of the Law Society of Kenya. He's joining us this morning. We're discussing implementation of the law, adherence and obeying the law and the Constitution, especially looking at the relationship between the judiciary and the other two arms of government, the legislature and the executive. This is a Situation Room. It's Kenya's biggest conversation, broadcasting on Spice FM on 94.4 Nairobi, Mombasa 87.9, 102.5 in Kisumu, Nakuru 96.0, 96.7 in Eldoret, Nyeri 90.9 and Malindi 97.7. Remember, we live stream the show as well on www.spicefm.co.ke, as well as on our social media handles, SpiceFM KE on YouTube, on Facebook and on Twitter. And the conversation also happens on Instagram, and our account is SpiceFM KE. In the room this and every morning, Eric Latif, CT Muga and Nduoko. And joining us on the line, looking dapper as usual, is the president of the Law Society of Kenya, Nelson Havi, in a very beautiful office. Nelson, we actually forgot to commend you. This is looking like a very, very nice office. I'd like to come and visit.
Thank you. We could have the next show here.
Well, there you go.
Excellent suggestion.
Indeed, that's a good one. So as we were going into the break, you were telling us, look, we're in a dire situation where we have an executive that is disobeying court orders, that is making resolutions and taking action that is constantly being challenged in court. 80% of those challenges being successful. Besides the political route of seeking reprieve as citizens, and that is going through an impeachment through the National Assembly, what other routes do we have? I mean, for example, what can the Law Society of Kenya do? What can the other institutions or civil society organizations do to ensure that we have a harmonious coexistence between the three arms of government, and that we are living in a country governed by the rule of law?
Thank you, Latif and Du and Muga. can we have a reprieve in court insofar as this matter is concerned? My answer as the servant of the Law Society of Kenya is we have exhausted legal avenues within the courtroom, but we haven't exhausted other options available within the Constitution. And that is why in the month of July, in particular on the 11th of July, the Law Society of Kenya Council passed a resolution to initiate proceedings for the expulsion of the Attorney General and the Solicitor General. This was intended to put pressure on them to bear for misadvising the President not to swear in these judges. But as is often the case, it is said for every 12 people, there'll be one traitor. There was a traitor amongst the judges who, in his wisdom or lack of it, decided to halt this process. Yet this is a process that is given to the Law Society of Kenya under statute. It is a process in which the Attorney General and the Solicitor General will have been heard to explain why, in their view and advice to the President of the Republic of Kenya, these 41 judges should not have been sworn in. As we speak right now, that matter is lying topid in the courts of law. The Attorney General and the Solicitor General comfortable that they are frustrated yet another judicial process that will have held them accountable or given progression to this matter. At the same time, the Law Society of Kenya Council has resolved unanimously that a petition be drawn and forwarded to the National Assembly and the Senate for the two houses to initiate and undertake the trial of the President of the Republic of Kenya for his failure to swear in these 41 judges, which amounts to a gross violation of the Constitution. That is what we can do as the two primary steps. There are other lawful means that can be undertaken by the Law Society of Kenya to put pressure to bear on the executive and in particular the President of the Republic. And one of those is what we are undertaking right now. Enlighten the public, informing them as to the cause of their problem, so that every Kenyan, be he or she in Gatundu, Moyale, Kisumu, or Eldoret, that the reason as to why you can't get justice is because of the person you elected to be the chief executive of this country.
So Nelson, if I could just go before you get to that, if I can just ask you, so if you're talking about then enlightening and informing Kenyans about what the problem is, so are you saying then that the appointment of these 41 or the non-appointment of these 41 judges then is just one problem? Is then that there's certain other things that are inherently wrong that need to be dealt with?
Absolutely, yes, do. I will mention just but a few. As we speak right now, we have collected close to 400 orders directed against the government of the Republic of Kenya, state agencies, state officers, and public officers, which have been disobeyed. Many of these are money decrees, and we're speaking about hundreds of billions of Kenyan shillings that the government has refused to pay wananchis who have judgments in their favor. What authority can such a government have to continue being in office? You want to be paid taxes by the citizens, yet you are holding billions of shillings that are due to the citizens, yet you are oversighting over maladministration, loss of public funds meant to combat COVID. That is one. Two, we have the failure on the part of the executive to comply with the 2/3 gender rule insofar as public appointments are concerned. Right now, there is a decision of the High Court that states that the cabinet is not gender compliant. We have a decision of the High Court that has found for a fact that Parliament is not 2/3 gender compliant. and has directed that the Chief Justice initiates the process of dissolution of Parliament. This, amongst many other visible issues like failed projects, where is the Big Four agenda? Where is the handshake? Where is the BBI? Where is the referendum? There is a call to amend the Constitution. Towards what end? Is the intention to amend the Constitution to tighten the Constitution so that we have good leadership, or is it to loosen? I think it is to loosen. And if you look at it from that panoramic view, you realize the manifest failure of this administration, which the people of Kenya must be made to understand. And perhaps this is the opportune moment for me to make a clarion call to the professionals in Kenya. We have this syndrome, we have this construct we call the silo mentality, where you as a journalist sit in your studio comfortable that you'll have a show of this kind, get your salary at the end of the month without caring why you need to have good governance. Same with the pilots, same with the doctors, same with the teachers, same with the architects. Why is it that it is only us lawyers who are in the forefront of demanding accountability? All these people must participate because they are beneficiaries of good governance. What about the religious leaders? We saw the Catholic Church come out strongly and admonish the administration. Where is the Anglican Church? Where are the Protestant churches? Where are the Muslims? Where are the Hindus? These are people who need to play a fundamental role in shaping the agenda of this country. What about our partners across the border and abroad? What is the European Economic Union doing? What is the East African Community doing? What is the United States of America doing? We saw their great involvement in yesteryears when they held the government of President Daniel Arap Moi to check, when Ambassador Sir Edward Clay lamented wanton corruption in the administration of President Mwai Kibaki, which he equated to vomiting fit. These people have kept quiet.
But which voices are we hearing? I know you campaigned on the platform of A Brave New Bar, where you were painting the picture of the yesteryears, where the Law Society of Kenya was robust in not just activism in the courts, but also in activism on matters of governance at all levels. Are we beginning to see that? Because we, so far with this big one, 41 judges who have not yet been sworn in, and you're saying that from where you sit, you have tried one move, you've tried another move, and all of them are being blocked. So first of all, I'd like to question, is there unanimity within the legal fraternity or the members of the Law Society of Kenya on the kind of action that the Law Society of Kenya should be taking, or the voice that the Law Society of Kenya should be raising, before we even go into the other professional organizations, which I completely agree with you, ISPAC, the AAK, the religious organizations, the Union of Journalists, and all of us should all be speaking about some of these things. But sticking with the Law Society of Kenya, are we seeing a brave new bar, really?
Yes, a brave new bar is now here. The lost glory of the society is back. To answer your question, is there unanimity? I don't think there is unanimity. And it will be turning logic over its head to expect unanimity in a democratic society. But I can say without any fear of contradiction that the position I speak about is one that is held by a majority of the lawyers. The government, of course, has infiltrated the legal profession, including even my council. We have government agencies that work hand in hand with some of my council members. We have moles who work for the NIS within my council, and many other lawyers who are sympathetic of the cause of government. They will always work hard to ensure that they weigh us down so that we do not propel the brave new bar agenda forward. But this is not peculiar to me. It happened to all those leaders of the Law Society who preceded me and had a transformative agenda that was intended to benefit the lawyers who practice in Kenya, and also the general public. And it must be understood that for a long period of time in the history of mankind, lawyers have played a fundamental role in ensuring that there is accountability on the part of the government. And the reasons for this are obvious, because first and foremost, the Constitution itself is a legal document. You therefore expect lawyers to be at the forefront of demanding its compliance. All other laws, and the Law Society of Kenya is now given more powers by the act that was put in place in 2014, because we participate a great deal in making appointments to boards, tribunals, and other state agencies. And if you look at it from that angle, you realize why the government will be determined to scuttle the agenda we have in mind. But we are not frustrated because we signed up for this assignment. Like I can tell you for now, you've seen in the social media in the last 2 days, very vehement appraisal by individuals who are clearly state agents pretending to be bloggers, who are keen on pursuing a narrative with the expectation that that narrative will slow me down, will slow my council, will slow a majority of my council and the Law Society from pursuing the agenda of calling for accountability. And you see, what we have been doing is exactly within the mandate that we're given by the statute.
Mr. Harvey, there are those who hold the view that under your watch, under your stewardship, the Law Society of Kenya has become an opposition political party. What do you say to these allegations?
I will echo what Reverend Al Sharpton said the other day. We are here for publicity. We are here to make public the grievances of the people of Kenya. And if doing so will equate us to the opposition, so be it. There is no problem. Because as we speak, we don't have an opposition in Kenya. Yet the Constitution contemplated that we have an active opposition. The opposition has been compromised. It has been bought. Parliament has been emasculated. The judiciary itself has been weakened. And if I may be just candid to the three of you, I receive calls. I'm visited every day by a majority of Kenyans, both meek and mighty, who seek that we speak on their behalf because they feel that there is no organ, there is no entity, there is no commission that can advocate for the people of Kenya to ensure that they benefit, to ensure that they get good governance. So that the lamentation that we are in the official opposition is very lame. It's without foundation at all.
So essentially, if I hear you correctly, you appear to be saying that the Law Society under your stewardship seem to be the only organ within the government of Kenya, within the boundaries of Kenya, that are actually fighting for the good of the common man. Is that what you're saying?
That is what I'm saying. And it is my plea to all other professional bodies to see the need to get out of their cocoons, to get out of their silos. Because when a society degenerates, it is the professionals who lose most. And when there is need for the society to change, to advance, it is the professionals who are always on the steering wheel. Because most of these professionals occupy the strata of the middle class. They're the ones that catalyze change. They're the ones that shape opinion. But if they sit back, especially through their leaders, then they leave a vacuum that is filled by hoodlums. You've seen these hoodlums always organizing meetings. And funny enough, most of our elected leaders, appointed leaders, go to the homes of these hoodlums. They're the ones who shape public opinion. How do we end up in such a scenario? Do we really need, as wolves, to be led by sheep?
But do
The
we
need for a paradigm shift.
do we hear really a strong voice then from the legal fraternity? If we just look at the implementation of this constitution, there are some gaps in the implementation, some glaring ones. For example, coming up with a formula for the implementation of the two-third gender rule in the National Assembly, looking at others, looking at how devolution has worked or has not worked, and the rampant and wanton corruption in all the 47 counties at the arms of the national government. Some would argue that we are only hearing the Law Society of Kenya coming out strongly when it's a matter that affects their members, because 41 of their members were to be appointed into levels of the judiciary. These are all lawyers. But when it comes to corruption, what strong action do we see? Not just words, but strong action that we see in the fight against corruption, in bringing out the issues of corruption, or even in prosecuting corruption matters in court. When it comes to the matter of the push and the clamor for the gender equity, we have not had a very strong voice from the legal fraternity. What do you say to that?
Let me dissuade you of this false construct, Latif. It is not that as the leadership of the society, we are concerned with the welfare of our members alone. We participate actively in many facets. For instance, the last of the issues that you enumerated, the two-third gender rule, that matter had been pending before the Chief Justice since 2017. My predecessor had not done anything despite spirited efforts by the women of Kenya beseeching him to intervene on their behalf. When they came to me in the month of July, it did not take me more than a week to ambulate into active action. And I went to see and gave them the wave that brought their agenda to the forefront. As we speak right now, the momentum is high that the Chief Justice must advise the President of the Republic of Kenya to dissolve Parliament. What about corruption? We have been in the forefront of fighting corruption. And it must be understood, corruption is not just about money. Corruption is about skewed public appointments that are propelled by cronyism, ethnicity, and corruption. And these have prevailed in this administration. We've gone to court and successfully obtained orders to stop these appointments. What about the prosecutions? Some of these prosecutions by the DCI, the Ethics and Anti-Corruption Commission, and the DPP are well-founded, but most of them are weaponized. It is for that reason, therefore, that I've always said where there is an unpopular suspect in court, I will be there to ensure that the scales of justice are balanced. For instance, ask yourself, where is the propriety in the much-hyped prosecution of the DCJ? Yet, we have so many people closely associated with the ruling class who have been involved with credible evidence available in mega graft, but they're not pursued. It's because the war against corruption is targeted, is used for a reason other than the vindication of the rule of law. What about the common Mwananchi? Remember, when the government...
Mr. Harvey, are you saying that those who belong to your profession are outside the boundaries of crime, that it is not possible for any of them to actually have committed a crime, or that all the accusations levied against such individuals are of necessity false?
No, not at all. In fact, there are many of my members who engage in active crime and have resolved with the support of my council and with the support of a majority of my members. And you saw me last week on Tuesday meet up with the Inspector General of National Police. We will deal with these rogue lawyers. We will suspend them, we'll strike them off the roll, and submit them to criminal prosecution. There are no sacred cows here. But what I'm talking about is the selective war insofar as corruption is concerned. You understand? Where certain agencies are used to stifle, to scuttle views of other people. Where Kenya Revenue Authority is unleashed on you when you speak openly when you call for accountability, where the Ethics and Anti-Corruption Commission is unleashed on you, when you take a view that is divergent from what is considered to be a popular view.
Nelson, you brought up the issue of professionals in Kenya coming forward and doing something about what would be the current situation. And I would like to, what exactly do we ask people to do? We talk about having conversations and making sure that the things that you see happening before you are actually overt in terms of awareness. What more can be done to actually bring about any kind of change or any kind of recognition that the people are actually aware of what is going on, beyond speaking about it, beyond being oftentimes in a public arena? What can really be done to bring about any kind of lasting or even evident change?
Many things can be done. Who is the governor of Vihiga? A professor of mathematics. Who is the governor of Kakamega? Who is the governor of Pokot? Who is the governor of Kiambu? Who is the governor of Nairobi? You see, as a people, if you don't get actively involved in the choice of leadership, then you'll end up being led by people of substandard quality, both in learning, in their profession, and in their ability to do good. Look at the Congress in the United States of America. Look at the House of Commons in England. It is dominated by professionals, lawyers, pilots, distinguished soldiers, journalists, doctors, engineers. How many of these do we have in the National Assembly? How many of these do we have in the Senate?
Many.
For instance, before the National Assembly right now, there is a bill, the effect of which is to collapse KQ and the Kenya Airports Authority. And there is nobody in the House who has the knowledge of this specialized field. You understand? And look, on our part as lawyers, we've always protected ourselves. We initiated a process to put in place a legal framework that anchors the society into law. And you will find that for that reason, we are recognized under the Constitution and many statutes as a body that must participate in decision-making for posterity and for good governance. What about the other professions? And I've reached out to the leaders of these professions and told them, for instance, the medics, we need to have a composite legislation that takes care of you. They must understand the reason as to why they are fragmented is because the government flourishes in divide and rule. They must come together, and as the Law Society will provide a platform through which they will express themselves. They will have legislation to make good use of what is available to adequately provide for their members. But more importantly, they must participate in the governance of this country. We must send doctors, pilots, engineers, accountants, and journalists to the National Assembly so that when an issue that is peculiar to that profession is before the House, it is adequately interrogated. Look at the revenue allocation. Why are these people bickering and making noise every day? Because they can't find the formula. The formula is in the Constitution itself. Where are they looking for it? They complain day after day that there is impropriety on the part of appointed leaders, in particular cabinet secretaries. They demand that they resign. Yet the Constitution, under Article 95, Article 5A, gives them the power to oversight these ministers and to remove them. Why? Because we put in office, individuals who cannot even read a newspaper. How do you expect them to read and understand the Constitution?
The Constitution and the law of the country. Some of the things that you've put out there are quite heavy stuff, Nelson, talking about the dissolution of Parliament, talking about censure of certain offices, asking for the removal of, the Attorney General and the Solicitor General and things like this. Like I said, heavy stuff. It would be seen that in some sectors it would be a blowing of hot air. Or is it actually something that is going to come to fruition? And what then?
No. It cannot be a blowing of hot air. Have you seen the bellows that were traditionally used to smelt iron?
I have actually, yes.
Yeah, they were productive. And we're not speaking the realm of conjecture because as I've taken you through this discourse, I've enumerated provisions of law that enable that which we demand of our leaders. And leaders must be held accountable. We may not achieve 100% of what we are required to achieve from this clamor, from these demands we are making. But when history is written, it will be known that it was during the 10 years of this administration that the Constitution was transformed into a paper for wrapping meat. Not even wrapping meat, wrapping the intestines of chicken.
Wow. Okay.
Nelson Harvey, very strong words, and thank you very much for speaking to us today. Nelson Harvey is the president of the Law Society of Kenya. He's joined us today to talk about the implementation of the Constitution, the role that the Law Society of Kenya has in oversighting and checking the implementation of this Constitution, and also looking at the appointment of judges. The 41 judges that were to be appointed, they've already been gone through the entire process with the Judicial Service Commission, but yet to be sworn in because of a standoff between the executive and the judiciary. Asante sana Nelson for speaking to us, and we look forward to another conversation in the near future.
Karibu, next time you come over.
For sure.
Yes,
thank
thank
you. Very
you.
much.
Indeed.
Have a blessed day.
You too.
Thank you.